We are live.
Good morning. Welcome to the Judiciary Committee's first briefing of the 2022 legislative session. It is January the 18th, 2022. It's a virtual briefing, so please be patient if we have any technical issues or streaming issues. Before we begin, I'll remind the committee that this briefing is being streamed on the Maryland General Assembly's YouTube channel. Committee members will be muted through the briefing. If you have a question after the presentations, use your raise your hand function. We're going to take questions through after each one of the groups of panelists. There'll be 4 groups of panelists. We'll hear today from Judge Morrissey from District Court. He's got a PowerPoint presentation. We'll then hear from remarks on behalf of tenants, and we'll have representatives from legal aid, pro bono, the Midshore Pro Bono Corporation, and then the Pro Bono Resource, I'll get it right at some point, Center of Maryland. We'll hear from the Maryland Multihousing Association and the Apartment and Office Building Association. They'll also have a PowerPoint, and then we'll hear from the Realtors. So we'll take questions after each one of those presentations. As a reminder, each panel is going to have a maximum of 15 minutes. We'll see if we can actually hold everybody to that. Again, our goal is to conclude between 12:15 and 12:30. So with that, we will begin with Judge Morrissey. Judge Morrissey is here, Chief Judge of District Court, and we will let you begin. I believe, Dylan, again, he has a PowerPoint presentation.
Thank you, Mr. Chairman and members of the committee. Dylan, if you could put up that'd be great. There's 4 basic case types, just to remind you all. I know I briefed you previously about this, but I'll just go over it very quickly, that there's failure to pay rent, there's breach of lease, there's tenant holding over, and then there's wrongful detainer. Currently, the court is in phase 3 of operations as a result of the spike in Omicron. And so one of the things in phase 3 is that we were not processing failure to pay rent cases right now. So no new ones are being scheduled. They're being filed, but they're not being scheduled right now until we come out of this phase, and that's going to last through at least March 7th, that there be no, so everyone's clear, there's no ongoing failure to pay rent hearings being heard at this time. The remaining items that were in the pipeline prior to that, or the other case types, are continuing to proceed. So if you go to the next slide, Dylan. So to show you, there you go. Just to show you the trends and what the filings are, if you look at the yellow, and this is by fiscal year, so if you focus on December in the yellow, that's the most current month data. So there was 23,183 filings made. That is less than what was made in December of last year. We were pretty much in the same position last year as a result of the spike in COVID last year at this time. But you can see that prior to that historically we had been upwards of 55 to 60,000 failure to pay rent filings. In the amount down of 23,000, failure to pay rents are the overwhelming largest number of cases that filed. And you'll see when we go to the next slides, but you can see that that's just the same, just in a pretty graph kind of thing. My graphic person is very good at what she does. So thank you, Rose, if you're listening. If you go to the next slide. So once there's been a failure to pay rent filing made, and if there is a judgment that's granted, the next step is for the landlord to file what's called a warrant of restitution. And that would be, if signed by the judge, authorizing the sheriff's department to proceed with the eviction. And you can see again, if you look at the yellow right there on the for December, that is this last month's data, there were 4,240 filings. That's somewhat consistent with what we were doing in the fall, and a little bit less than would have been the trend in October and November. One of the things, and again, this is historically down, the main reason I believe that it's down is the result of the ERAP monies being distributed. There could be other factors that go into it, but it seems that is what's accounting for a lot of the lower numbers that have been pretty consistent throughout the whole pandemic. If you go to the next slide, please. And again, that's just a graphic depiction. If you look at yellow, that's the trend since July of this 2021 through December to right there. If you go to the next slide, please. So how many evictions have occurred? And if you look in December, there were 558. That's been pretty consistent. It's down a little bit from September and October, but it's been pretty consistent since we've been up and operating. When you look at some of the earlier numbers in the pandemic in April, May, and June of 2020, that's when we were at the heart of it, and the court were only handling emergency matters at that time, so no evictions were occurring. But since July of 2020, they've been moving at about the pace that you see here, somewhere between 500 to 700. And that, again, is historically below where we were prior to the pandemic, which would be over 2,000. If you could go to the next slide. And again, that's just a graphic pictorial of it. It's been pretty flat across the last 6 months in terms of evictions. Next slide, please. You can see where it was historically and then down. We started to get affected by the pandemic in fiscal 2020, the last 3 months, 2021, the whole year, and then 2022. And we're on pace probably to do about 8,000. It looks like if trends continue, 8,000 to 9,000 evictions this year. Although I think that number is going to be down because we're not scheduling landlord tenants as a result of phase 3. So phase 3 didn't start until late December. If you go to the next slide, please. So the next case type is breach of lease filings, and that would be there needs to be a significant breach or substantial breach of the lease in order to bring these filings. Someone would have had to do something in violation of the lease agreement between the parties. And again, if you focus on December, those numbers are 191 were filed. So you can see that there were over 23,000 failure to pay rents, 191 breach of leases. Could you go to the next slide, please? These are for tenants holding over, and tenants holding over would be when the lease is expired and then the landlord is moving, not because of failure to pay rent, but because they no longer, the lease is terminated at that point and they want to remove the tenant. And again, if you draw to December in the yellow, there were 446. That has been up prior to the pandemic by about 300 per month. But again, the numbers dwarfed by the amount of failure to pay rents. And you can't come into court with a failure to pay rent that's disguised as a tenant holding over. Judges won't allow that. You have to have the proper noticing requirements for a tenant holding over and a copy of the lease to show that it's expired. If you go to the next slide, please. And then wrongful detainers are when the person in your house has no legal right to be in your house. If you think perhaps it was an adult child in your house that you no longer want in your house, there can be a lot of reasons where that could fall in, but it's not used that often. You can see in December there were 163 of those filings, and that's been kind of consistent throughout the whole pandemic. The next slide, please. This is by legislation that you all passed last year. This is the new notice of intent to file a complaint that's required to be filed 10 days prior to the filing of the complaint itself. And it is being used widely. I sat down in Charles County not too long ago, and everyone that I had to have that on there. And there was only one person out of the probably 10 or 15 cases that I did that was not aware of that particular provision. We also have a QR code that we implemented in. If you go to the next slide, the notice also provides for all the nonprofit legal services organizations out there. Just a couple other points and then I'll stop. The self-help centers, both the walk-in centers, some of those have switched over as a result of the pandemic to being completely remote, but some of them are still operating. And the remote center that we have serviced over 10,781 instances of service in December. And 27% of those, or almost 3,000, were housing-related cases. So the self-help center continues to do a yeoman's job for the judiciary. We're very pleased with the work effort that they do, and it provides a real benefit to the citizens of the state. Moving forward, we also have all of the larger ones, and most of the other courts have some type and have coordinated with some of the legal service providers And thank you to all of them that are the pro bono community out there that are volunteering their time and services in court. And we're also in most courts making announcements about the rental assistance. I know I did when I sat in Charles County, and I made sure that whoever the individual there was from the pro bono, I believe it was legal aid. I acknowledged that individual, had him stand up, and told anybody that needed to talk to him to talk to him. And then finally, we've been working with our own internal access to justice department here in the judiciary, a new RFP for a time that will create a liaison position or a coordination position for whenever the access to counsel gets funded and they really start doing this in earnest. That person will act as a coordinator of those and to try to provide a little extra service so that we can make sure that we're fulfilling that bill when it ultimately gets funded. And they can, as soon as we get the RFP and hire someone out, they can start even without any further going with the access to counsel initiative. We can coordinate what we're already doing. And it will be set up somewhat similar to our mediation department. And we're going to start with a contractual person first. And then if that's working out, we'll probably come back next session and ask for another pin for that position, or pins, depending on the volume of what that person is going to do. So that's my status update, Mr. Chair. I'd be happy to answer any questions of anyone. I'm very pleased that the ERAP money is being used and being spent, and it looks like it's working well. It's increased every month. I read an article recently, I can't remember where, but they said November had the highest amount of monies that were distributed through ERAP so far. So thank you, Mr. Chair and members of the committee.
Thank you very much, Your Honor. I have a couple questions quickly, and then we're going to go to delegates Holmes, Williams, and I think Hardin. I think don't see his hand raised, but okay. But the question I have has to do with how these are filed. And we've talked about this, I think, a little bit in the past, but I think it's important to talk about it again. When people file for a failure to pay rent or any of the other filings that are here, they're filing it in a paper form. Is that correct? Or can they file them electronically?
In Prince George's, they have an e-file solution, but everywhere else it's in paper, and you can still file in paper, and the majority are filed in paper in Prince George's.
So is in Prince George's where they have the e-file solution. Is that Delegate Conway, if you could go on mute until I get to you, that would be great. If it's possible for you to answer, the information that is put into the e-file system in Prince George's County, does that go into MDEC, or does that sits in its own system to the side of MDEC?
Right. It's not in MDEC, and it can't be put into MDEC. All it is a e-filing system. It just allows the landlords to electronically file their complaint to the court, but then it's printed out and maintained in paper. And that's when you hear about other courts, we decided to do both. You hear about some courts where in a year 35 counties went to e-filing, and that's only half of the solution, because those people aren't telling you that they're printing everything out, maintaining it in paper. What MDEC does is both. It allows for the e-filing solution and then for us to electronically maintain that information. We went live in Montgomery County. They're the 22nd of 24 on October 25th. And I'm pleased to report that the transition was seamless despite COVID, and my hat's off to both the circuit court and the district court staff and judges and clerks. And it was a real team effort. They even have their own mascot named Monty for the go live, and they had a video that they produced that's very clever, and it was by all counts a wild success.
Well, I'm very pleased to hear that they had a mascot. That's fantastic.
It was great. Great team spirit.
Wonderful. That's fantastic. I appreciate that. I guess my broader question is, would it be easier to begin to file these kind of cases and you've put the data together, and I appreciate the way that you've put the data together here, but it feels like for a process that moves very, very quickly, for it not to be in an electronic format has got to be an additional burden on the court. Is that true?
It is, and we're in the testing phases. We have a product from our vendor. We're in the testing phases right now of trying to get it to work, and I intend to launch that in Baltimore County prior to the end of this year. I can't give you an exact date yet because we're catching some hiccups in testing, and each time that happens, then we have to get the vendor back involved, and it has to go through additional development. But that is the intention, and we've discussed with some of the larger landlords that are more sophisticated. To kind of be the test pilot on this in Baltimore County when we go live. And then, as soon as we have success there, then we will roll it back to the other 21 counties that are live, and it will be part of the go live when we go to Prince George's in Baltimore City.
So they'll be part of MDEC. It won't be a separate system.
That's correct. It'll be native to MDEC.
All right. Thank you very much. Let's go to Delegate Holmes, please, then Williams, Cardin, and Conaway. Delegate Holmes from Environment and Transportation.
Thank you, Mr. Chair. I have 2 questions, and I do believe they will be very, very brief. Good to see you, Judge Morrissey.
Nice to see you. Thank you.
Yes, indeed. The first question is, we've been hearing for a couple of years now that we should be expecting an eviction tsunami. And my question to you, I want you to put a brand new quarter in your crystal ball and then indicate to us if that tsunami is coming, and if not, why not? If so, why?
Well, I haven't seen a tsunami yet. I can't really predict the future, but I can say that the ERAP money is causing filings to be, subdued. And also when we go through these phases, like we're having right now, where there's a spike and we have to limit the amount of people in court, it slows the process again. So I think the combination of those two, really the ERAP money, is what's slowed the pace of everything. And it's I'm fortunate that we had that amount of funding.
Thank you, Judge. And I do want to, while I'm here, applaud Prince George's County for their efforts in the ERAP money, because they're getting out very, very rapidly. Also, Judge Morrissey, you showed us in a slide the paper notice provision, the paper notice for failure to file. Does that form have on it the MDE certification number? And have we yet to coordinate that MDE certification number with MDE for lead paint certifications?
I don't believe it has the MDE number on it. It's not a filing that's made for court. It's kind of unusual that this is the only form that we've ever been asked to create that's not a court form, in the sense that it's never filed with the court. It's given between the landlord and the tenant. And the answer to the second part of that question is no, there is still no coordination between the two. They do have to, in the complaint itself, they have to file the licensing number.
Yes, but as we all know, that licensing number has no way of being verified. Thank you, Judge. Thank you, Chair.
Thank you. We'll go now to Delegate Williams, then Cardin, Conaway, and McComas.
Thank you, Mr. Chair. Hi, Judge Morrissey. I have a quick question. Thank you so much for the presentation. The one question I had, I noticed with the tenant holdover cases, they're much higher, I guess the post-COVID ones, than prior to the pandemic. And I'm curious if you have any insight as to why that is.
It's probably, I'm speculating, but it's probably because people have just been in place for longer, and for whatever reason, the landlord decides they don't want to renew the lease. But again, you have to provide the notice. I believe it's 60 days notice before you do that, and they can't fake a tenant holding over for a rent case. People may owe them money, but we're not gonna. The judgment's not going to include $1 on it.
Thank you.
Delegate Cardin.
Thank you, Mr. Chair. Thank you, Judge Morrissey, for being here. You and I discussed a few weeks ago about issues related to the effect of having records not available. And I have a client recently who said that she was unable to get an apartment because the landlord did a quick background check on her and found that she had an open case, said that the case has to be closed before he will rent to her. I don't know whether that's allowed or not. I'm not, this is not my area of law, but if they do background checks and then cases are then,
turn on the flashlight.
and then cases are then,
Delegate Anderson, would you please put your computer on mute? There we go. Never mind. Go ahead, Delegate Cardin.
If she gets that case null process, it's automatically expunged, but they still have it, or it's automatically gone off the case search, but they still have it in their report, she's gonna have a hard time getting housing.
It's not well, let me tell you how it works. So when we went live in Anne Arundel County back in 2014, I wanted to maintain the database for electronic filing, knowing that we were going to at some point or another have a fully electronic rent process. So what they do is they back scan any dispositions in, and then ultimately, if disposition, meaning if there's a judgment, and then any dismissals after that. So all of that then becomes electronic, and then it is visible on case search. But there's a lag time on it. It's not contemporaneous. It's sometimes it can be months late. And with COVID, that's impacted the ability to do that. One of the reasons why we need to get this electronic system in is because you can imagine how much time it takes for them to scan these in, and it's not sustainable moving forward. So we really need to have this electronic system so they won't have to back scan in. But in civil cases, there's typically no expungement of civil case types.
I was referring, she has a criminal matter, and because of that criminal matter that's outstanding, she's having a hard time getting an apartment, or a lease. And the question is, if, for example, I have that case null processed, but they still have this old report, and then she can't then, if it's automatically taken off of case search, how can she show that it was null processed unless she goes to the courthouse and gets a printout?
Well, that's a problem, and it's a bigger problem than what you just said, because if it's truly expunged, then the courthouse isn't going to have a record at all either. And one of the things we've been trying to do with case search is limit the amount of screen scraping that's gone on. We realized that there were lots of screen scraping going on, and so we instituted CAPTCHA. You all have probably seen this before, where you have to authenticate that you're not a computer before you can get into the system. And so we've instituted that. But people, had been and probably will in the future download, information from case records and then put it into their own database, and there's no effective mechanism. These can be private entities, not us, or public safety or anyone like that, but private entities, and they can maintain those databases on their own.
All right, we'll go now to Delegate Conaway.
Good afternoon, Judge. Good afternoon, Mr. Chairman. In reference to the notice to file complaint, that notice comes from the landlord and is given to the tenant, and it's supposed to be given 10 days in advance. Is that correct?
That's correct.
How does the landlord prove that they submitted that or that the tenant received that?
I can tell you from my own experience, when I was sitting in landlord court in Charles County, that I would ask to see it, and they would show me a copy of it, or they would attach it to the complaint when they filed it.
Who is they? The landlord?
The landlord.
So let's say the landlord posted it on someone's door, and the person says, "I never received it." Is that valid, or?
Well, that would be a factual issue that the judge would have to decide.
All right. Thank you very much.
Thank you, Delia. Nice seeing you again.
Delegate McComas, then Erican.
Thank you, Mr. Chair. Just briefly, I just, if Judge Morrissey is aware of this, what ERAP is federal funds or federal and state funds? And the other thing is, in other words, is the landlord aware that these funds have been given to the tenant? Because I'm just wondering if the tenant then can decide to spend that money to pay the rent, because I think it goes through the tenant, or it doesn't go directly to the landlord from the government. I don't understand the mechanism, so I was wondering if you were aware.
I'm not an expert on this subject, but it's my understanding that in the overwhelming majority of the counties that it goes directly to the landlord rather than to the tenant. I know that there have been some places that are experimenting with giving it to the tenant also, but the money is to pay the rent. And that's the programs that I'm aware of are all getting the money to the landlord. The tenants have to agree and the landlords have to agree to it. And I think you'll hear later from the landlords that they're in a lot of cases assisting the tenants to ask for that money.
Okay. All right. Thank you, sir.
Thank you.
Delegate Erican.
Thank you, Mr. Chair. Good to see you, Chief Judge. So I just want to dovetail off of what Delegate Cardin just had mentioned. I also was contacted by an attorney who helps people who have previous records get them expunged. And he's having trouble with clients who don't even know if they need to have something expunged because it's been deleted. So unless they have access to that case number or whatever, that they're not even able to ask to get it expunged because they're not able to find it anymore on case search. Is there something we're doing to address this issue right now?
Well, the reason why they can't find it on a case search was because of legislation that was passed last year that required us to block any case that had a null pros, a judgment of acquittal. It didn't say not guilty, but we put not guilty in there because it's what you should, it's one of the case types that should be blocked if we're going to block those types. And those are all blocked out of case search now. So if you have a case that was completely null, you're not going to be able to find that on case search.
Right.
You can at the courthouse, though. You can come to the courthouse and you can find it either on the kiosk or you can ask the clerk to help you with it.
So they would just look up by their name to see if there's anything still in the system, because
That's
they're having
correct.
problems with what Delegate Cardin said, getting, being able to rent and get jobs because there's these charges out there that they don't even realize they still have hanging out there that have never been expunged.
Right. And the second piece of legislation that you all passed too is that those cases will automatically be expunged as opposed to blocked from case search, right? Which is what's occurring right now. Those will be expunged automatically 3 years from October 1st of 2021. Or the people, we're advising people in court that if they have a favorable outcome like that, that they can file immediately if they want. They just have to file and we condense the form from 2 different forms to 1 form so that you can file for the expungement and file the general waiver and release also as 1 form. And they could do that. A lot of times I'd say, go walk across the hallway to the clerk's office and get this form and file it before you leave the courthouse today. Otherwise, it'll be expunged 3 years from today if you take no action. So that's
Okay.
also going to be.
Okay, thanks for clarifying. I appreciate it.
Sure.
All right, thank you. I believe that'll be the last question to Judge Morrissey. Thank you very much, Your Honor. We appreciate your time this morning.
Thank you, Mr. Chair.
Thank you. We're going to move now to remarks from 3 people who represent tenants across the state. This is Melissa Chiesera, Gregory Countess, and Meredith Gerard. And if I mispronounced any of those names, they'll let me know. We'll hear from them. We're going to try and keep it to 15 minutes. And although we kind of did a disastrous job of doing that with the last person, but that's not to be knock on anybody. We'll just try and do a little better this time. All right. Let's let you go ahead. And who would like to go first? That's Chiesera.
Sure, I can go.
Go ahead.
Thank you very much. My name is Melissa Chiesera. I am with the Pro Bono Resource Center of Maryland. we're a legal services organization that runs day of court clinics in Baltimore City District Court and Baltimore County courts as well. We help tenants with failure to pay rent complaints. Like I said, that's a day of court thing, so we see a lot of this. And we use folks from the private bar to volunteer for pro bono work. We also handle breach of lease and tenant holding over cases as well, but the main kind of cases we take are the failure to pay rents. And as Chief Judge Morrissey has been discussing, those numbers are certainly down than they from pre-pandemic due to, of course, I do think some of the ERAP funding has reduced some of the filings, and of course, the limited docket sizes are greatly reducing the number of tenants that we see. However, with the tenants we are seeing, the vast majority of our clients do qualify for the ERAP funds. So what that means is that they have had a substantial financial impact as a result of COVID. That's kind of the main thing that would qualify a tenant to receive those funds. And much of what our job is right now is helping the tenant coordinate with the program and to get that moving at a quicker rate, because by the time we see them in court, they have usually already applied some months ago and have only heard crickets because the programs are so overwhelmed. They just can't get to all these folks. So the legal service organizations are jumping in as middlemen to try to get things expedited. And that's a lot of what we have been doing I would like to think to great success, but I am noticing currently things are really slow right now. I have seen several clients where the landlords have basically thrown in the towel and they're not willing to wait anymore, and they're starting to proceed forward with evictions. So a lot of it is just us trying to come up with another mechanism that allows the tenant to stay in their housing. And it was mentioned, there was a question earlier about how this money is received. And at least with the programs I work with, it's always direct funding the landlord. And so if the landlord's not willing to participate with the program, then the tenant is between a rock and a hard place. There's nothing really they can do because most of the programs are really reluctant to just give the monies to the tenant. Sometimes when attorneys intervene, we've had a couple instances where at least the right to redeem amount, what we call pay to stay, sometimes that can be given directly to the tenant so that prior to the day of eviction, they can redeem and not be evicted. But I would highlight this as the significant problem that we're seeing and trying to work on right now, is just trying to, this group of tenants that are already have judgments are the particularly worrisome folks. And now that the failure to pay rent dockets are suspended, we're not getting new judgments that way. But there are a whole group of tenants that have a judgment and the program hasn't paid their back rent yet. So that's kind of the tricky spot these days. And we do notice the uptick of tenant holding over cases. And as the courts remain closed, that may even uptick a little bit. There are some landlords who can't get into the failure to pay rent docket. It is still, particularly in Baltimore City, it's pretty far behind. And so as a way, the landlord just doesn't want to wait around. And because so many of these tenants are on a month-to-month lease, it has worked in some instances better for the landlord to just serve the 60-day notice. And if ERAP funds haven't been paid by then, they keep moving forward with the tenant holding over, which, it's perfectly within their right to do. Obviously a landlord does not have to renew a lease if they don't choose to. And, if they haven't been paid in months on end, many landlords are going that route. I have a feeling other colleagues probably want to speak more on all of this, so I will stop talking at this point and pass it to one of my colleagues.
So I guess I'll go next, Mr. Chair and members of the committee. My name is Gregory Countess. I'm with Maryland Legal Aid. For those that are not familiar with Maryland Legal Aid, it's a nonprofit law firm that provides free legal services to the state's low-income and vulnerable residents. We handle civil cases involving a wide range of issues, including housing, family law, public benefits, consumer law, i.e. Bankruptcy and debt collection, as well as criminal record expungements, which may remove barriers to folks obtaining employment, child custody, housing, and a driver's license. If I can, I'm going to divert from my remarks just to perhaps answer a question. I know Delegate Holmes said, where's the beef? That's not what he said, but I think that's what he was referring to in terms of where's the tsunami. And what I would say to that is that the tsunami is rather slow moving. As a matter of fact, when we go back and take a look at least a partial look at our records, comparing 2019 to 2021, the number of housing cases that we receive inquiries from that we have perhaps closed rose by about 45%, and in numbers that comes out to about 1,561, and that's preliminary look. We're still trying to do a deep dive into that. So something's happening, and it's increasing the level of concern for the public, for folks that we represent, and they're responding by contacting us. There was another question asked about receipt of ERAP funds, and those funds going directly to the tenant. And I would agree with my colleague, the overwhelming majority of tenants assisted through ERAP, those funds are paid directly to the landlord. And in the few jurisdictions in which those funds are paid directly to the tenant, it's because the landlord has refused those funds. And in most cases, I'd have to speculate, but I would think that the reason that they refuse those funds is because they're barred from taking any sort of eviction action, whether it be failure to pay rent or tenant holding over, for 90 days. We've had landlords who have, in fact, rejected the money for that reason. In terms of tenant holding overs, we are seeing an increase in tenant holding over, and I respectfully disagree with Chief Judge Morrissey. As a matter of fact, back in 2020, we had a landlord who was bold enough to put in writing to the tenant, we can't, because we're not licensed, we can't fail to pay rents. The property was not covered by the CARES Act. The CARES Act forbid back in 2020 on the filing of these cases until, excuse me, August of 2020. And the landlord said, I'm not a CARES Act property. I'm not covered by the CARES Act. If you don't pay me the rent, we're going to send a tenant holding over notice to you and take you into court. And that's exactly what they did. So in many cases, these cases tenant holding overs are, at least recently, masquerading or substitutes for the landlord's perceived inability, or in some cases because they're not licensed and so they're not adhering to the law, inability to file failure to pay rent cases. Be sure to shorten this up. The legislature enacted an amendment to 8-401. We found that this provides an opportunity for tenants because it requires a notice before the filing of a failure to pay rent. And at least potentially, this notice gives an opportunity for tenants to talk to landlords about the rent, clarify issues before trial, and perhaps get counsel if available. It also narrows the inquiry, that is the issues that appear before the court, which saves both the court in the litigant's time. However, there's a concern that even with that 10-day delay before the filing of the failure to pay rent complaint, that it in and of itself may not provide enough time. And we will see, I guess, over the weeks and months ahead. In terms of ERAP does seem to be going well. The agencies are, in some cases, because of the landlords, particular landlords' rejection of those funds, concern that they may in fact file an action to evict the tenant after receipt of those funds. Then some ERAP providers are allowing the money to be used for relocation, and we're hopeful that that will continue and expand if we have landlords rejecting these funds. There's still a concern because in some jurisdictions, the problem of having to put together a whole new program is telling and slowing down the provision of these funds in some situations. We had someone apply early last year. They even got approved, at least they thought they got approved back in June, but they still have not received those funds. And that can cause a problem. The ERAP program has stepped up in cases where folks have judgments that have been rendered against them, and therefore they're facing an eviction. The ERAP programs are in fact expediting those applications so as to provide funds for the landlord. So that is something that is going really well. There are some problems in terms of courts enforcing the terms of the ERAP, which forbids the filing of an eviction action, whether that be failure to pay rent or tenant holding over or breach of lease. There may be a need to explicitly provide, in fact, that judges should dismiss these cases after receipt of those funds, or else what we're doing is landlords are being paid and then tenants are still suffering homelessness, which goes against the purpose of those funds. I'll stop talking right now.
All right, we'll go to Ms. Gerard, please.
Thank you, Chair, and thank you, committee members, for your interest in this issue. My name is Meredith Gerard. I'm the Executive Director of Midshore Pro Bono, and we provide free and low-cost legal services to folks in our community here on the Eastern Shore who can't afford an attorney. We serve the 8 Eastern Shore counties from Kent to Worcester, and we have offices in Easton, Salisbury, and Chestertown, and we provide those services through our network of volunteer attorneys. We have about 200 attorneys in our network who do this for our clients pro bono. We handle about 3,000 clients a year, and about a third of those clients have issues related to housing and consumer debt, which are directly related to financial stability for local households. Since spring of 2020, we've been providing in-court services, direct legal representation for rent court in Eastern Shore counties. And I would agree with the other panelists that overall, the rental assistance is absolutely working. It really is keeping people from being evicted in most of our counties. We work very closely with the rental assistance agencies, and we coordinate very closely on every single client to make sure that they're getting through this process. Not every county, or some counties are doing an amazing job with this. And, in particular, Queen Anne's County and Caroline County have been superb. We have some challenges with some of our other jurisdictions. Dorchester County is a place where we've not been able to secure rental assistance funds for most of our clients, which is very disappointing. The 10-day notice is also has been effective in slowing down the process. It helps people to have an opportunity to learn about the rental assistance if they haven't already been educated about it. Sometimes landlords aren't sure or don't know about it, and sometimes the tenants don't know about it. So it does help, but oftentimes 10 days is not enough time to get completely through the process. But it is slowing down and giving folks an opportunity to apply. I do want to address this question about tenant holding over, and the charts that Judge Morrissey showed, that we're having a larger number of those cases, and I can absolutely attest to that. My assessment from what we're seeing in court is that when tenants have a month-to-month lease or their lease has run out during the pandemic, landlords have very little incentive to keep those tenants in place because there's such a shortage of housing that they can evict that tenant based on a tenant holding over. There are so few defenses that the tenant has to be able to protect themselves, and they can be evicted, and then the landlord can charge a higher rent. And I've had landlords say this to me directly: I can get this tenant out, and then I can charge it a higher rent because demand is so high right now. And I would say also, big picture, we're just seeing more homeless clients than we've ever seen before, which is really disheartening. So, big picture, having counsel almost always leads to a better result from the client. The leadership of the legislature and helping to improve the situation for tenants is really, really appreciated. Recently, one of our volunteer attorneys helped 2 clients in Dorchester County who were single moms who had lost their employment during the pandemic. The attorney, our attorneys are doing kind of full wraparound service for these clients. They represented them in court. They negotiated with the landlord. They helped the clients to apply for rental assistance and had to be very persistent in getting those applications approved. But they did it. And these tenants are now staying in their homes, and they're not going to be evicted. So, the combination of legal assistance with the rental assistance and having assistance from a council and other organizations and resource organizations that can help people negotiate and navigate those systems is incredibly helpful. So that's all I have for you. And thank you so much for your interest in this issue.
All right, questions for this panel. We'll start with Delegate Conaway.
Thank you, Mr. Chairman. I believe this question should go to Ms. Chisera. I hope I said that right. And my question is, if the tenant fails to pay the rent and they have a long-term lease, let's say a year, and they still have 8 months on that, you made a comment about the landlord throwing in the towel. That's Ms. Chisera who I'm addressing this to. And I want to know, is that do you mean the landlord using an improper eviction or an eviction without the court's approval, or what does that mean?
No, it means that rental assistance is so slow and so far behind that the landlord is tired of waiting for this rental assistance. Because what happens is we'll get the failure to pay rent in court, and if the tenant's represented, oftentimes we'll make arguments for a postponement. Sometimes we'll do a stipulated dismissal with a deadline, just trying to buy time for rental assistance to catch up, because 99% of the time, the tenant qualifies. They qualify for the rental assistance, and rental assistance will pay, but they're so overloaded right now that it's taking quite a bit of time. And as my colleague, Ms. Gerard mentioned, the housing market is hot right now. So the landlord's thinking, how many months more do I need to wait to get paid, right? And
so the eviction does have the proper
absolutely, yes. They're just moving forward with the failure to pay rent complaint, as opposed to saying, okay, I'll wait for ERAP money, because ERAP takes too long.
Wonderful presentation. Thank you.
Sure.
Are there further questions for this panel? Seeing none, we thank you all very, very much. We'll now go to remarks from the Maryland Multi-Housing Association and the Apartment and Office Building Association. We'll hear from Aaron Bradley and Grayson Wiggins. Are they on?
Yes. Good morning, Mr. Chair.
There they are. That's fine. Ms. Bradley, if you'd like to begin.
Sure, thank you. And we, as we so often do, we have a joint presentation. So good morning, Aaron Bradley, representing the Apartment and Office Building Association with Grayson Wiggins from MMHA. Next slide. So as you can see here, MMHA and AOBA collectively represent 750,000 Marylanders across the state. We serve multifamily housing industry by providing advocacy, promoting education, and professional standards. So next slide, please.
Thanks, Aaron, for that lead in. Grayson Wiggins with the Maryland Multi-Housing Association. So I've learned over the past year and a half or so that I cannot compete with Judge Morrissey's charts, but this is a humble attempt to frame the data that Judge Morrissey shared with you in a different way. This is the number of evictions per month from January 2019 to November 2021. So as you can see, there has been no eviction tsunami. In fact, there has been an inverse of a tsunami. So why is that? Well, there's a few reasons, and Judge Morrissey mentioned a couple: rental assistance and the delay in the court process. Though I do respectfully think he may have understated the delay in the court process. Baltimore City is anywhere from 5 to 8 months between a filing and a hearing. Prince George's County is a year. Montgomery County is 9 to 10 months. That is only going to be extended with the recent delay or pause, whatever you want to call it, for failure to pay rent cases. The other piece that was not touched on is that the significant work that housing providers are doing to connect tenants with rental assistance. Our members are spending tens of thousands of their own dollars, significant staff time and effort. I've got members who have created impromptu computer labs to connect tenants with rental assistance. They are walking door to door, attempting to do anything to get people to apply and make them aware of the process. And that has had a significant impact on the number of evictions in this state, as you can see based on this chart. Again, no eviction tsunami. We heard predictions of that early in the pandemic. We heard them again in August when the federal eviction moratorium ended. It just has not come to fruition, and we do not anticipate a tsunami based on the data that we have available to us. Next slide, please. So this is another way to view it. This is the November data. So this is November 2019 compared to November 2021. So pre-pandemic and post-pandemic. And as you can see here, filings declined by more than 63%, warrant of restitutions declined by more than 53%, and evictions declined by 61%. Again, this is good news. And this is really indicative of the consistent and continued efforts of both housing providers and other stakeholders on the ground across the state of Maryland. Next slide, please.
I'm going to touch briefly on the state benefit of multifamily housing. So 48% of Maryland's apartment homes were built before 1980. As a result, we spend a lot of money in preserving housing stock so we can provide a quality, affordable housing. We contribute $1 billion to the local economy annually and creates 5,000 jobs. I'm sorry. The operation of Maryland's apartment homes contribute $3.5 billion to the local economy each year and create about 6,000 jobs for Marylanders. And just a reminder, Maryland requires 6,000 new apartment homes annually to meet its growing population needs, to house all the growing population. Next slide, please. I think we've touched on where we stand with rent court quite a bit. I will actually skip this. As we know, the court is in phase 3. Phase 3 operations will be until March 6th. And we know we've talked about at length what that means. So next slide, please.
Right, so this is a summary ejectment process. We thought it'd be helpful to walk the committee through what the summary ejectment process looks like in Baltimore City. So as you can see, and this has been talked about by previous speakers, the first step is when rent is unpaid, a landlord will provide a notice to the tenant that includes contact information for free attorneys across the state. And based on research that we've seen, Maryland now has one of the longest notice periods of any state in the country. The second piece is that if a tenant doesn't pay during that 10-day notice period, then the landlord can move forward with a filing. So, but prior to a hearing, so after a filing, a hearing is scheduled, but prior to that hearing, tenants receive 2 additional forms of notice. The sheriff mails a notice and they post a notice to the door. So at that point, the tenant has received 3 forms of notice. And as I previously mentioned, the time between a filing and a hearing right now could extend up to more than a year in Prince George's County. But in Baltimore City, we were seeing most recently 5 to 6, 7 months. That will be longer now due to the pause. After the hearing is scheduled and the tenant receives the 2 additional forms of notice, the hearing occurs. The tenant gets to go before the judge, plead their case, and the judge considers the facts and makes a decision. If a judgment is entered, the tenant has a right to appeal that decision. After the appeal period ends and prior to an eviction being scheduled, the housing provider must obtain what's called a warrant of restitution. This is the second part in the eviction process, which is reviewed and signed by a judge and then sent to the sheriff. This takes significant amount, a couple of weeks as well in many cases. The sheriff then schedules the date of eviction, and 2 additional forms of notice are sent to the tenant. So this is notice number 4 and notice number 5. One is sent 14 days before the eviction, and the other is posted to the door 7 days before the eviction. Now, here's what's important to remember. The eviction is then scheduled and can take place, but a tenant reserves the right to pay and stay. You've heard this sometimes called right to redeem. The tenant reserves the right to pay and stay up until and including the date of the eviction. So if the sheriff shows up and the tenant has money, the tenant absolutely has the right to pay and stay in that property. That is up to 3 times a year in the state, 4 times in Baltimore City. Next slide, please.
So Grayson walked us through the summary ejectment process in Baltimore. We'll just talk about the current court process as well. So between rent being unpaid and the eviction taking place, a tenant receives numerous notices. There's a hearing before an impartial judge, and they're also provided contact information for free attorneys, an opportunity to appeal, and the right of redemption. So during that process, the more than 97% of tenants are able to avoid eviction with numerous ways to do that. And the state recently pledged $7.5 million to help in this process by pledging that amount to the Access to Counsel program. So as we've said a few times, the total time between rent being unpaid and eviction may currently, right now, exceed more than a year, depending on the jurisdiction, 5 to 6 months, 9 to 10 months, but upwards of a year in Prince George's County. It's also important to note that housing providers are required to make 2 payments during this process. So there's the filing fee, and then there's the warrant of restitution fee. Next slide, please. And this slide provides an overview of the process. Grayson, did you?
Sure, yeah. And I just want to clarify one thing. The previous slide noted that $7.5 million have been pledged for access to counsel. Our understanding of that is that 5.4 was recently pledged by the Department of Housing and Community Development from federal funds, and there's an additional 2.1 or so million that was discussed by MLSC during the Access to Counsel Task Force. But I'm assuming you'll be hearing about that later this afternoon. So this is a 2-payment process. What you have here is an example of the filing fee and the additional fee that must be paid by landlords during the eviction process in the state of Maryland. So the first column is the state of Maryland, second column is Baltimore City. And then you just have a comparison here of Virginia, just to give the committee an idea of the total cost that are currently involved with the court process as you move from the initial notice through to the end where an eviction may be scheduled. Next slide, please. So this is the summary ejectment filing fee, right? We've heard a lot about this. We heard a lot about it last year. We just wanted to get a few, things put on the table so everybody's aware of it. So raising the filing fee and making it unrecoverable, and that's really the key part here, making it unrecoverable does not align Maryland with surrounding states. The unrecoverability aspect of that filing fee would actually put Maryland in a position that is the complete opposite of our surrounding states, which all allow a filing fee to be recovered. recoverable. And so that's the second bullet point here. As I mentioned, every surrounding jurisdiction allows for a filing fee to be recovered. DC, Delaware, Pennsylvania, Virginia, West Virginia, even states like New York allow for the filing fee to be recovered. And our mantra, so to speak, has really been let the judge decide. So as impartial arbiters of justice who are aware of the specific facts of each case and are undoubtedly members of an impartial judicial system, our mantra and our consistent talking point has just been let a judge decide. They are in the best position to understand the facts of each case. Next slide, please. So this is the right to redeem, and I talked about this a little earlier. And this is just, again, a tenant can pay and stay after a judgment, but up until the time of an eviction, 3 times in the state, 4 times in Baltimore City. But it's important to note that tenants may pay after a filing, but before a judgment, so before a hearing, indefinitely. So that there is no limit to that. Tenants reserve that right indefinitely. So just something to consider when we think about filing fees in situations like that. Next slide, please.
And thanks. And we'll just leave you with this, a reminder that rent collection is how property owners generate their revenue and pay their expenses. So we just want to highlight that only 9 cents of every dollar of rent goes back to the owner. 10 cents goes to maintaining the quality of the property through capital improvements and capital investments. 14 cents goes to pay property taxes. 27 cents of every dollar of rent goes to the 6,000 employees across Maryland that maintain rental housing, and 39 cents of every dollar of rent goes to the mortgage. So just want to leave you with that, and I think I'll turn over for questions.
Well, I would like to quickly, if I may, Mr. Chair, just interject, and I want to talk about briefly just the idea of unintended consequences and the unintended consequences that policies have. You're going to hear some references throughout session about Washington State and other jurisdictions. And Washington State, it's important to remember that they have triple the homelessness rate of the state of Maryland. They have really regulated themselves into a homeless and housing crisis out there. According to a 2020 annual homeless assessment report to Congress by the U.S. Department of Housing and Urban Development, Washington had the 3rd highest absolute increase in homelessness from 2019 to 2020. So you're going to hear about some policies in Washington State. I just want you to be aware of the unintended consequences that those policies may be having out there. Thank you.
All right, are there questions for this panel? Delegate Bartlett, then Cardin. Bartlett.
Thank you, Mr. Chair. My question is to, I guess, Ms. Bradley. With the slide, which was a beautiful slide with the dollar bill, but I don't understand it. I understand in general how one could state where the money goes, but I don't understand collectively how the data was, how you came up with, or whoever came up with where the money goes. So for instance, was there a survey done for landlords or, because quite frankly, as a landlord, I could charge whatever I want in my home, and I may not even have a mortgage, right? So my home could be paid for. So I'm just trying to understand how that data was derived.
Sure, Delegate Bartlett. That comes from the National Apartment Association. So that is for professionally managed multifamily apartment communities primarily. So they, yes, they did. This is from the 2019 Survey of Operating Income and Expenses in Rental Apartment Communities. And it also utilizes census information. So it was put together by our national organization looking at professionally managed apartment communities. And so that is, of course, related to the roughly 2/3 of apartment communities that do still have a mortgage. And yes, yes, that is true for small independent landlords, but this is, of course, related to who we represent, which is primarily professionally managed property, multifamily communities.
And I understand, I appreciate your answer, but there are multi-apartment homes that do not have a mortgage. I intend to be one day, but anyway, thank you. I appreciate that reference, and thank you, Mr. Chair, for allowing me that question and the second bite.
Thank you, Delegate Cardin.
Thank you, Mr. Chair. Very quickly, Mr. Grayson, real quick. So the reimbursable fees, I would philosophically completely agree with you. In fact, isn't it true that a judge makes a decision on whether any fee that is incumbent on a party can be waived in all other matters outside of landlord-tenant? I mean, maybe you don't know, but as far as I'm concerned, as far as I know, a judge basically has a right to make a decision as to whether to waive fees if it's appropriate in all other matters as well.
I believe there is a provision that allows judges to waive fees for indigent individuals. I do believe there's a provision. I'm unsure of exactly how that interplays with landlord-tenant law. But I do believe there's a provision.
And if a party is going through an entire process and goes through multiple different efforts, and then it's determined, or he or she pays the amount to be able to redeem, or it's determined that they do owe the money, from a public policy standpoint, shouldn't all the efforts that party had to make to get the other party to comply should probably be reimbursed, shouldn't they?
Yes, and I believe that parties are treated that way in other types of proceedings in front of the court. And as long as a party comes in good faith to the court, and if they win the case, the judge decides that they have a good case, then yes, I completely agree that they should be able to recoup the cost of that proceeding. And
finally, what you're saying is that if they do win the case, and they should have a right to get reimbursed, but the judge says, this person's really struggling, they can't afford it, the judge has the right to say, sorry, you're not getting that money back.
Yeah, they have a right to decide.
Okay, thank you.
Are there other questions for this panel? I have a couple questions. I have a broader question that does not or has not yet shown up in the charts, and I think it's difficult to. I think it's almost proving a negative, but I'll ask the two of you, because it might be your members who are the people who are not filing complaints. And that could come across in the wrong way here, but bear with me for a second. Is it possible that people are not filing complaints also because in some jurisdictions across the state, including in Baltimore City, they are casting a tougher eye on people who are filing these requests for rent to make sure that they've actually done what they're supposed to do according to city, in the case of the city or local jurisdiction law, with regard to permitting, with regard to making sure that they're doing everything that they're supposed to do as a landlord. Is it possible that greater attention is dissuading people from filing these claims?
Based on the information that I have seen, no. I'm sure that there may be an anecdotal case here or there where that could be the situation, but on the whole, no, I think that rental assistance, the significant delay in the court process, and the work being completed by members like ours to get people connected to rental assistance has much more of an impact on the number of filings.
Okay. I'm going to go to Delegate Howell for what I believe will be her first question. So there's absolutely no pressure at all on this. Delegate Howell.
I just have a general question about ERAP, and it makes me wonder, why would landlords not want to accept it? But does ERAP pay, what portion of their rent does ERAP pay?
Aaron, you want to? Go ahead. Okay, so the ERAP pays, it usually pays all the rent. So it pays 12 months in back rent and 3 months in forward rent is the eligibility that I'm aware of. To your first part, and by the way, I'm happy to be a part of your first question and welcome to the committee.
Thank you.
But to your first question, there were some concerns about some of the agreements early in the process, specifically in places like Baltimore City, where there was confusing language, and the agreements there were some concerns about with the language in the agreements. Thankfully, MMHA we worked very closely with Baltimore City to iron that out. and we were able to get the agreement changed. And so my understanding now is that that agreement, the issues in that agreement have been ironed out.
And so I will just chime in. Also in Prince George's County, AOBA was able to work in the very beginning with the ERAP program to develop a program that didn't have issues. And so to my knowledge, none of the housing providers I represent, AOBA represents, have turned down payment in Montgomery or Prince George's County. That's, again, anecdotal, and I'm sure it's happened to some people somewhere. It's just not the overwhelming majority, and it's certainly not people that AOBA represents. And as Grayson said, MMHA, they work to take care of that. So there's no real burden to accepting the ERAP payment.
Yeah, and we have also worked with United Way of Central Maryland very closely to develop a wonderful rent program called the STEP program. I believe it's the Strategic Targeted Eviction Prevention Program, the STEP program, and it allows landlords to apply in bundles for their tenants, and it expedites rental assistance getting out to landlords on behalf of tenants and resolving a lot of these issues.
Thank you. I do have a second question. ERAP, as far as ERAP is concerned, does the renter have to pay back any of that money?
No.
Okay.
No, they are able right now to self-attest and that they had a hardship or are eligible for the funds. They do not have to pay it back. I would note that landlords cannot unilaterally apply for ERAP funds. So we have to have involvement from the tenant. There's not a program that allows landlords to unilaterally apply and receive funds.
Okay, thank you. I appreciate that.
Of course.
Delegate Conaway. Delegate Conaway.
Can you hear me?
Yep, go ahead.
All righty, thank you. In reference to the comment that the ERAP can pay up to 12 months back rent and 4 months forward rent for hardship, is that something that the tenant would ask for? I mean, the tenant could say, I anticipate having another 4 months or 6 months worth of hardship, and I would like to apply for the maximum. How does that work?
So I believe it's actually three months of forward rent, but it really depends on the program and the individual situation. So the tenant would inform the program of what they need or what they may be eligible for. And my understanding is that the 3 months of forward rent can actually be used if the tenant wants to relocate as well. Aaron, is that your understanding?
Yes, I believe so. We also, in the programs that our housing providers can apply in bulk, the programs that I'm aware of that the housing providers can provide in bulk, they would provide the rent ledger as well. When they're providing on behalf, when they're applying on behalf of the resident, they provide the rent ledger, and with the lag time in ERAP, that's where the 3 months also can come into play.
Thank you very much. Thank you very much.
Thank you.
It's fighting with me. All right. Thank you very much. I have one last question. When you indicated again, going back to the fees that are charged, and to, or I should say the summary ejectment fee that's paid to district court. I don't think I've ever heard of a lease that did not charge a late fee. When the money is requested from the tenant to pay for the summary ejectment charge, is there any reason why does that need to be collected from the tenant on top of the late fee that's already being charged to the tenant?
So just to be clear, late fees are capped at 5% by law. And you're asking why would you need to charge an additional fee on top of the late fee?
Why do you have to recover the fee for the summary ejectment in court on top of the late fee that you already received?
Well, the late fee for the summary ejectment in court is reimbursement.
Those are two different things. There's
Right.
the late fee in the terms of the lease and the summary ejectment fee. Why are you charging both?
So the summary ejectment fee is a reimbursement for the court cost, the price of having to go into court because the tenant did not pay the rent. The late fee does not, so just to give you an example, depending upon the amount of rent involved, if the Attorney General's bill that was recently dropped were to pass, the late fee may not cover the court cost because late fees are capped and they're based on the amount of the lease. So there are certainly situations where the cost of going to court are going to dramatically exceed any funds that would be accrued from a late fee.
The late fee is capped at 5%, is that correct?
That is correct. It's a standard number, yes.
Right, so then the late fee on a missed rent of $1,000 would be $50, is that correct?
That would be 5%, yes.
So the fee of $15, what would the rent have to be?
Well, I mentioned if the Attorney General's bill were to pass, it would exceed.
I'm just stating what it is right now. What would the rent have to be?
Well, you have the $20 plus the warrant of restitution fee, which is $60.
If somebody were actually evicted, if we got to the 5% of the people who are actually evicted at the end of the story.
No, the warrant of restitution is before the eviction. It's not only before, you can pay after the warrant of restitution. So at that point,
all the steps, through all of the steps, the 5% of the time.
Both payments, yes, you would exceed the $1,000 5% right now.
Okay. Thank you all very much. Thanks for your part of the presentation. We're going to go now to the Realtors, and we'll go to Bill Costelli, the Senior Vice President for the Maryland Realtors. Go ahead.
And thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Happy New Year. Bill Costelli on behalf of the Maryland Realtors. We're a 30,000 member trade association in Maryland, representing real estate brokers and agents. About 30% of our members are involved in property management in one way or the other, some as owners of rental property, some as managers of rental property. We differ a little bit from the previous panel in that most, in fact, almost entirely all of the portfolio our members represent are single family rental properties. These are kind of smaller, people call them mom and pops, who might have 1 to 2 rental properties. Nationally, about most individual investors in rental properties have about 3 to 3.5 units. So these are smaller actors. Sometimes they're represented by a professional, like members of our association. Sometimes they self-represent. And I would just say quickly, there are 4 points that we would make. ERAP, I would say our experience with ERAP is a little different in that there is, especially with some of these self-represented landlords, a knowledge gap in terms of the program, comfort with trying to figure out how to get to the program. As you've heard, because there is a significant amount of people applying for the program too. Sometimes there's delay in terms of responses. If you're self-representing in a landlord, this is not your full-time job and you're doing other things. So that delay can also delay you in terms of, helping and working with the tenant to get that assistance. And sometimes the tenants are reluctant to apply for the assistance as well. And I think sometimes that's a knowledge gap issue as well. The other thing that we see is just the way the program was designed. Even though it's self-attestation in terms of applying for the program, you do have landlords who will see that there are income restrictions and that, you do have to self-attest that you have some housing instability, income loss, things like that. And so sometimes they're a little bit reluctant given some of those eligibility requirements in terms of applying. So some of this is information in getting out, but we do believe that ERAP funds have helped significantly in terms of both on the landlord side and on the tenant side. And then finally, or not finally, but in terms of the landlords and the loss of revenue, especially with some of the numbers we've seen, it has been significant during this period. You've had about 37, some of the numbers I've seen, 37% of rental properties that have had, about a 10% loss of income during this time. So that would theoretically be money that the ERAP would address. But you also have about 9% of the properties with over 50% loss of income and again, that would be money that potentially ERAP could address. Other panelists have raised the housing supply. We think that's a big issue. We know that there's about 87,000 units of undersupply of housing in the state of Maryland right now. That is driving a lot of the things that we talk about at the legislature. There's more competition among tenants for housing, particularly affordable housing. There is, just not enough, particularly affordable housing that many tenants want to apply for. And that leads to that competition and why tenants end up applying for many, many different units sometimes because they're competing with a lot of other folks. Part of what's driving the portfolio issue too, in terms of tenant supply is, and this is all very anecdotal, but among property managers that we've interviewed, anywhere from about 3% to 20% of their portfolios are actually being sold. That is part a reflection of the market, a very strong real estate market where people who have had single family rental properties are now saying, hey, I'm going to take advantage of the strong market. It's partly a reflection of the fact too that some landlords have struggled with non-payment of rent and have just determined now is the time to exit. So, this is, when you look at single family properties, we're about, somewhere in the neighborhood of about 41% of the rental market. So there is that component of it as well. And then finally, I would say foreclosures is something to take a look at as well. And while I'm not sounding an alarm about foreclosures because we're still below kind of historic levels of foreclosures, there is no question that now that the forbearance period has ended, lenders are free to pursue. And you've seen filings, notice of intent, notice of foreclosure filings have increased in the state. Those don't always translate into foreclosure. In fact, the vast majority of the time, they do not translate into foreclosure, but they have increased significantly as the forbearance period has ended. The state has a great program that they've got up and running to help homeowners, but that doesn't really address, for example, the rental property owners, because you do have to be, it has to be a principal home, some of the state assistance on the foreclosure side. So I would say those are all components to keep in mind as you move forward and consider these issues.
Okay. Are there questions for Mr. Costelli? All right. Seeing none, I'm going to thank him. Thank everybody who came to present to us today. I think Mr. Costelli is getting off easy, but that's all right. We'll let him go. That's fine. I want to thank everybody for being here today and appreciate everybody's time and expertise. If we have follow-up questions for any of our panelists, they can email my office or contact Dylan, and we'll be sure to connect you with the presenters today. I'll see our committee members on our next Zoom for our first virtual bill hearing of the session. The Zoom link was previously sent to your email inboxes. As a reminder, we have another briefing scheduled at 2 p.m. after our bill hearing at 1. So again, we have a bill hearing in 34 minutes. And then we have another briefing scheduled at 2 o'clock with Attorney General Frosh. So fairly busy day here in Judiciary, which is completely unusual, of course. If anyone, I don't see any further questions, and we want to thank everyone for being here for today's briefing. Thank you very much.